Welcome back. You're watching us in the India development debate. Now, the quota controversy is continuing to be at the centre stage as the top court bench today has said that it will examine the centre's decision to implement 10% quota in jobs and education for the economically weaker sections. The bench, comprising of Chief Justice Ranjan Gogoi and Justice Sanjiv Khanna, issued a notice to the centre seeking reply now within the next 4 weeks. But in a relief to the Modi government, the Supreme Court did not stay the implementation of the quota. For which aspects of the quota bill will the Supreme Court examine then, and what are the constitutional challenges for the government? Will the government be able to roll out this big quota carpet before the Lok Sabha polls? Well, these are just some of the questions that we will be putting forth to our expert panel this evening, and let's get straight to it. Welcome first who we have with us on the show. Gopalkrishna Agarwal, spokesperson for the BJP, joins in. Adil Singh Boparai, spokesperson for the Congress, is here with us. We've also got Nitin Meshram, who's an advocate of the Supreme Court. Well, let's get straight to it. And Mr. Meshram, let me begin by asking you, the Supreme Court has put no stay on the implementation of this 10% quota for the economically weaker sections, but says it is going to examine the validity of the constitutional amendment bill. You know, let's start by understanding what your thoughts are. Do you think that this violates the basic tenets of the Constitution and the Supreme Court's various judgments on reservation?
Absolutely. It violates the basic structure of the Constitution. Because you see, when the Constitution was being framed, the framers of the Constitution were discussing the exceptions to the equality. And equality being the central idea of the Constitution, they have only provided the exceptions of SC, ST, OBC reservation. And therefore, any other exception other than the SC, ST, OBC reservation is essentially against the very idea of the equality, and therefore it violates the basic structure of the Constitution.
Gopalkrishna Agarwal, the Supreme Court has, issued a notice to the government, giving it 4 weeks now to respond. Given the premise of the petitions, for instance, a 50% ceiling limit cannot be breached, how does the government plan to explain its rationale in the next 4 weeks?
I would like to mention that the Constitution puts the responsibility on the government to look after the weaker sections of the society. And it's in the preamble very clearly mentioned that it is the responsibility of the government to look for processes and means to create the equality into the whole society. And that responsibility, the government derives that power from that responsibility, how to act, what are the inequalities, what are the areas, concerns, what are the segments of the society which needs reservation. The second important point that some people are talking is about Article 14 and 15 and the ceiling of 50%. For that, I would like to mention is that it is particularly based on caste that the ceiling is put on. Because the Article 14 and 15 says that the 50% reservation upper caste is also not in the Constitution, not in the law, but it is that the Supreme Court orders in some cases, Indra Sahani and other cases have put that as a guiding note that you should not go above 50%, but there no provision is there with regard to 50% upper ceiling, and that too those two articles only deal with caste reservation. SC, ST and OBC specifically is mentioned. The third point I would like to mention is that this weaker sections reservation 10% quota is for the people, and there is no caste or anything which requires this reservation. It is within 10% quota is within the 50% left for general category. General category of citizens, population of India, and it also work specifically for the weaker sections.
Okay, let's take it across to, yes, sure, we'll come back to you, Mr. Agarwal. Let's just, also hear out Adil Singh Boparai. Now, Adil, many would say that, of course, the Congress is supporting this 10% quota for the economically weaker, but you've also directed a fair amount of criticism the BJP's way. Is the fear here that it could help the current dispensation win votes, particularly of the Patels in Gujarat, the Marathas in Maharashtra, the Jats in Haryana, Uttar Pradesh?
Well, Taneia, firstly, let me tell you, this was the Congress party's brainchild. It was the Congress government under P.V. Narasimha Rao which came out with a similar legislation. It's a different story. It was set aside by the Supreme Court and then the Indira Sahni judgment came. But let's be very clear, as far as affirmative action for the economically weaker sections of society is concerned, we support it in principle. But having said this, there are several legal challenges and the BJP cannot run away from that. The mandate of law is that the government of the day must have carried out an exercise to collect quantifiable data. So the first categorical question to Mr. Agarwal is, have you carried out such exercise? Number one. Number two, how do they arrive at this cutoff figure of 8 lakhs? This in legal parlance is known as classifications. So there has to be empirical evidence to indicate why did the government arrive at this figure of 8 lakh rupees. Now coming to the larger issue of reservations, jurisprudentially, reservation is linked with representation. It is not linked with economic deprivation as the sole criteria. And this I say on the basis of the judgments of the Supreme Court. Now, economic deprivation is certainly a criteria. Nobody is saying it's not a criteria, but given the mandate of law and as the law stands today, it is socio and educational backwardness as well. So I think the government will have to satisfy the court on these counts. But you know, with every passing day, it's becoming more and more evident that Mr. Modi did not do his homework. There is growing anger, there is palpable anger with this government on account of joblessness. So this appears to be a jumla by Mr. Modi on the eve of the elections to perhaps deflect attention from his own failures. But we support this in principle and we hope the government is able to persuade the court. Otherwise, this is nothing but betrayal.
Mr. Agarwal, I will give you a chance to respond to it, but before that, you know, it's only fair that we give everybody, you know, a viewpoint here, and so I'm going to take it back to Nitin Mishra. Nitin, the 10% quota bill was passed by clearing, you know, the 124th Constitution Amendment. Now, my question to you is, do you believe that this amendment alters the identity of the Constitution, as many have argued? Can judges sort of override constitutional amendments on the basis of the fact that it, you know, tampers with the basic structure?
Look, you know, we will have to see whether this constitutional amendment was conceivable when the constitution was drafted. And according to me, it was not conceivable because it was not conceived by the constitutional framers. Secondly, that the amendment violates many of the principles laid down by the Nagaraj judgment of the Constitution Bench of the Supreme Court, because it does not provide for the quantifiable data, it does not provide for the indicators of the backwardness, and also it violates the very first judgment of the Supreme Court, which has held that we do not provide the reservation under the Constitution on communal lines. So this is an amendment which provides the reservation to certain sections of the people on their communal lines. And what happens, I'm telling you, that under the Constitution, the reservation is considered to be an exception. You read many of the judgments of the Supreme Court and you would come to know that the reservation is an exception exercised by the state governments to provide certain representative benefits to the certain classes. So now if you take away the principles of the equality from the Constitution and distribute certain percentage of reservations to certain classes, that is surely going to violate the principles of equality. And therefore, that is certainly going to violate the principles of equality, because you see, now here is the ceiling limit of 50% that is also being violated. Now you have provided beyond the 50%. Now, providing beyond 50% is also violative of many of the judgments of the Supreme Court. So, what was not conceived, because Constitution cannot be rewritten through Article 368 of the Constitution through amendments. It can only be supplemented through some amendments to make it more workable. This amendment is not made to make the Constitution more workable, but it is made to make the Constitution totally exactly opposite to what it was conceived by the constitutional framers, and therefore it is not going to sustain, I'm telling you.
Thank you for that, that view. Gopal Krishna Agarwal, let me give you a chance to sort of respond to the Congress spokesperson. was this a decision taken in haste? I mean, you know, there's also criticism that if the Supreme Court indeed agrees to lift this 50% cap, you've got all states of the country that can extend the quantum of reservation, and then maybe the upper castes will stand to lose out on, say, state government jobs. On the flip side, if the court sort of rejects the idea of breaching that 50% cap, then quotas will need to be provided for, but then you're going to be eating into, you know, quotas that are already in place for the SC, the ST and the OBC community. So how do you respond to that?
There are 2-3 issues we need to clarify. First thing, when the Congress spokesperson says that it is our brainchild, then why they are criticizing now? So whether we should first discuss whether there are inequalities in the society. Those inequalities are based on economic differences also. If those differences are there, then those weaker sections require support from the government or not. If we agree to all these things, and if Congress also agrees, then they should welcome. Now the second issue is whether it is constitutional or not, whether the Supreme Court will uphold it as a constitutional violation or will uphold. Because earlier whatever had been done were done by administrative orders. Reservation, when they were increased beyond 50%. First thing is, the Supreme Court has not anywhere in the Constitution provided that 50% is the upper cap. It is a guiding principle that has been put by the Supreme Court in Indira Sahni case, but there is no constitutional amendment into that, and this has been brought as a constitutional amendment. Now the third then question arises, whether the legislative has the power to amend the Constitution or not. So that also we agree that it has been validly passed through a legislative amendment, and Parliament has the power within itself to amend the Constitution, and this is 124th amendment. So the legislative, when it has the power to amend the Constitution, it is within the power of this legislation. It has been validly done. Earlier it was not done through amendments, it was on administrative orders, and still we have in some states reservation up to 69%. So the thing is very clear. There is a responsibility on the government to address the inequalities. Weaker sections need support. We have done it through a proper process of amending the Constitution, and we have also saying that 50% reservation clause is for Article 14 and 15. That only talks about SC, ST and OBC. We are talking of the general categories. And how it has become a communal, I don't know, I could not understand why Nitinji is saying that this is a communal amendment. The another important factor that I would like to mention is, people are criticizing that we have defined 8 lakh as a below income of 8 lakh as a economically weaker section. Nowhere in the bill you read every word. Government has mentioned it as that the 8 lakh is the criteria for determining the economically weaker segments. It is only in the press note that the cabinet had come out, and that also it had said that it's an indicative and upper cap limit.
Right. Okay. Let's take it across to. Yeah, let's bring Adil in as well. Adil, as you heard, and we've also heard on the floor of the House, the government's justification for this 10% quota is based on correcting historical injustice that was meted out to lower castes for centuries, which resulted in their backwardness. Now, in that sense, do you believe that providing quota to the economically weaker sections somewhere belies the principle of historical injustice?
Well, Tanya, we agree with the idea and principle. I say this at the cost of repetition, but to arrive at a conclusion, there has to be a survey. There has to be empirical evidence. If tomorrow you make an assertion, let's say X assertion, you must back it up with data. This is the question which I put to the BJP. Have you carried out such an exercise? Mr. Agarwal was going in circles, but he couldn't answer this pinpointed question. Number 2, where are the jobs? The recruitment through the UPSC has come down drastically. Lakhs of jobs are lying vacant, whether it's the railways or other central public sector industries and enterprises. Mr. Modi is just not serious. There is a huge trust deficit. That's why we asked this question. Are you indeed very serious about it? Because these are the challenges which you'll have to face. We agree with the idea, but you must see it through. Otherwise, this is treachery. Mr. Modi has a habit of making lofty promises, but he just can't take it through. I'll give you numerous examples. Let's take 2 crore jobs for the youth of this country. Doubling farmers' income, 15 lakhs in every bank account. So obviously the country will ask, there is a huge chasm between your promises and actual delivery. Have you complied with the mandate of law? Did you carry out an empirical evidence survey? Do you have data? On what basis did you arrive at this classification? These are legitimate questions. Mr. Agarwal talks about 69%. Let me point out that's the case for Tamil Nadu. But Tamil Nadu had carried an extensive survey, and that's why the Supreme Court upheld that 69% reservation. Has the government of India carried out such a survey? Was this even put out in public domain? Their own ministers were clueless, Taneia. You come up with such a historic decision. Their own ministers did not know about it. Their own allies did not know about it. So that is why we're asking, is this a decision in haste, keeping elections in mind? Will it be legally sustainable? Let's speak on specifics. Let's speak on tangibles. That's the moot point today.
Let me take it across, back to Nitin. Nitin, the Supreme Court has to now examine the principles on which affirmative action is based. Quite honestly, it's a lot of legalese, but, as per I think the M. Nagaraj judgment of 2006, the court is to now apply the width test on the boundaries of, the amending power. Can you just explain to our viewers both the constitutional and legal position, regarding including the exclusion of the creamy layer?
Look, I would say about the constitutional amendment, that constitutional amendments judged only on the basis of basic structure doctrine. So therefore, some of our colleagues are mentioning about the Indira Sahni judgment and the ratio of that judgment. I would say that the ratio of the judgment in Indira Sahni is not that applicable, because they were not considering the constitutional amendment in the constitution, and they were only considering the OM, which was challenged before the Supreme Court during that time. Secondly, they have evolved the creamy layer principle therein, and also subsequently the Supreme Court reiterated that creamy layer is an economic ceiling, and that has not actually supported by the constitution at all. That is a judicially evolved concept to exclude the affluent classes of the society. But see, now in this matter, they have provided for the economically weaker sections. Now, the constitution does not provide who is the economically weaker section, and that criteria has to be adopted by the executive fiat under Article 73. Or it has to be provided by enacting certain legislations by the parliament. So we have 2-3 issues that they have not provided for the economically weaker sections. I mean, the definition of economically weaker sections. Secondly, the Supreme Courts have actually said that the affluent classes has to be excluded from the provisions of the reservation. Now, the government will be caught in difficulty as to provide who are the economically weaker sections, because the Supreme Court precedent is binding upon them. Creamy layer principle, though it is not supported by the constitution, it is presently binding because they have not amended the constitution. Secondly, no discussion took place in the parliament on the Supreme Court's that particular precedent, and they have not reversed it. So therefore, in my view, when Supreme Court will consider the amendment, they will only consider whether it violates the basic structure of the constitution, and they will also not consider the economic ceiling of economic ceiling, that is the creamy layer, because that is not the part of the basic structure of the constitution. So that particular process is not going to happen in Supreme Court. Supreme Court will only consider, and that is the only principle they will have to consider, whether it violates the basic structure of the constitution. And they have in many judgments said equality is the basic structure of the constitution.
Okay, all right.
So,
okay.
Yeah.
Yes, thanks. Gopal Agarwal, you had the HRD minister, Mr. Prakash Javadekar, sort of saying that the government colleges and universities will increase seats by some 25% to accommodate the 10% reservation for students from the economically weaker sections, so that the existing quotas again for the SC, STs and OBCs and general seats don't get impacted. Now, if the Supreme Court refuses to, allow the breach of that 50% cap, I'm just wondering if this is constitutionally tenable.
No, I think that this increasing of seat has not only connotation with regard to 10% quota, it is otherwise also required. We have a young population which want education, which want skilling, various faculties are required. So that in itself is a process for educationally empowering the young population of the country. But still that reservation of some of the people concerned that our seats will be lost to this reservation, I don't think that basic logic is not tenable, because it is not for particular caste, it is across the caste, across religion. So whoever is opposing this, I don't know what is the basis of their opposition. Are they people opposing just because there is no economic inequality, or they are saying just because it will not be tenable in the Supreme Court that they are opposing? So let Supreme Court decide whether it is constitutional or not. But what I think is, what our government think is, that it is the Constitution which has put us this responsibility that all sections of the society should be empowered, and that empowerment comes only for economic empowerment. And this is an important step. This is the need of the hour. We have taken it. We have done it through a constitutional amendment, and we consider it within the this constitution. And Supreme Court, if it wants to have a different idea, different decision, then also we will see. But as far as legislative is concerned, the parliament has the right to amend constitution. That is there, though there are some cases in the Supreme Court where they say the parliament cannot amend the basic structure of the constitution. For that, we have to say that constitution puts the responsibility on the government to address the weaker sections society's requirement. So I think on all front there is clarity. It is opposition which is in confusion. If they are supporting, they want to support, they want to oppose, what there is, nothing is clear. If they want to say only let us see that the Supreme Court upholds, otherwise we are supporting it, then it's all right, we agree with them.
Okay, Adil, please do respond to that. While the lack of jobs, something that you've sort of already made your point about, is of course a very big issue for the government, and it has to admit its failure in the last 4.5 years. Don't you think that this is also something that will provide the best practices of how to keep away the creamy layer, from perpetually enjoying the benefits of affirmative action by sort of clearly demarcating the cutoff parameter?
Well, Talia, I'll tell you what's the problem with Mr. Modi and his style of governance. It is trust deficit. That is why the people of this country are not willing to accept a single word which is said by Mr. Modi. Now, I have a pointed question for Mr. Agarwal, and I would ask him to respond before I complete my statement. Did you carry out any exercise to collect data and empirical evidence to bolster this before a court of law? Because this is what the petitioners have said. This is a pointed question for you, Mr. Agarwal.
When you are saying that it is our brainchild, did you carry out any survey or any data collection on that basis? How did you say that we support this, it was our brainchild? So that in itself is an important thing. So
that answers my question.
If you deny that there is no equality,
that answers my question. Can I statement now? That answers my
please,
question.
yeah.
Without
this is
those
analysis,
clueless.
Adil, please make your point. And I have
that
just
answers
30
my
seconds
question.
left on this debate. So Adil, please, yes, please make your point.
Tanya, Skill India is a flop. Smart cities are a flop. Make in India has been flop. There are no jobs. Farmers are committing suicides. Agrarian distress is at an all-time high. Law and order is completely deteriorated. Institutions are being demolished in this country. This is what Mr. Modi stands for. Reservation seems to be another, this EWS seems to be another ploy by Mr. Modi to deceive the youth of this country, but we sincerely hope he manages to persuade the court.
Those
because
are different
as of
issues
today, and given what Mr. Agarwal has said, I don't think they have a strategy in mind to address
I think
the
those are
arguments
completely
before the court.
different issues. It's not, the scope of our discussion for tonight. And in fact, I think with that, the bickering isn't going to stop. So I'm going to thank all of you for taking the time out on the India Development Debate for us this evening. Gopal Krishna Agarwal, Adil Singh Boparai and Nitin Meshram, thank you so much, gentlemen.